Alright, we are back with the promissory note demonstration. Just so that you know, once again, none of this is legal advice. This is just research, educational purposes only. This is for thctrust.org members, and of course premium members, those who support our organization by donating $24 a month. We make these templates available for you, and again, these are for you to modify, build on top of, make stronger, use appropriately as you see fit. So what you have here, this is so here's what I'm working from basically. This is the whole presentment. It includes all the notary certificates of service. This is not the whole thing, but this is most of it. This is the initial presentment, if you will. It includes the affidavit, the promissory note, the notary certificate of service. What else? We're going to just kind of go through briefly. The UCC financing statement, a copy of it, a copy of a Form 56. Just the critical things that you would need at this point. There's even a request for a statement of accounting, because we want to establish evidence that the account has been zeroed out after we present the note. That's at least on the administrative procedure side. We like to attack this on multiple different angles, so that's the administrative procedure side, but there's other angles where we're trying to get this dealt with at an ACH level so that the accounting gets taken care of. And as you always, and if you don't know, I always do things in a PDF. I try to give you access to the Word document version of things, but I always do things in a PDF primarily because I want you to get an idea of how significant or important it is that your documents make an impact. So, I may have a lot of different errors and things in here, but I want you to get an idea of, okay, hey, that looks professional. See, I try to line everything up, so spend some time learning how to do that so people can take your documentation serious. So that's why I do it in PDF, so it doesn't lose the format, so you can get an idea. But when you actually begin to copy and paste and edit and do different things, that's what the Word document is for. thctrust.org is the website. Under this circumstance, you are presented an obligation or a payoff statement to close an account. We're using the promissory note. Here's the obligations for $115,000 and some odd dollars. When I was first creating this note to resolve a transaction, I was thinking in terms of tendering the promissory note to the financial institution or to the service company or to the attorney, tendering them the promise to pay per se. But then as I further my research, and I don't want to go into all of that research right now, I thought it would be best that the note, that the actual borrowing or the actual promise to pay is a promissory note issued to the trust by the trustee. It's more of a private transaction governed under the rules of the trust, governed under the policies, the internal policies or the internal operating procedures and bylaws of the trust. It's really just bylaws. All those other procedures and government stuff, that's government agency talk. So, but that being said, a promissory note is always a contract basically, so go get yourself a promissory note template. There's a website, I think it's called US Legal. You can Google US Legal Forms or something, and I bet you can find a good promissory note on there. It probably wouldn't cost you more than $15. I think it's going to cost you about $6 to be exact. If you did do your own promissory note, I think you want to have a witness on the front. I think I came across that somewhere. Aside from the notary, if you did download some form of a promissory note and it didn't have that, I might include a witness and a notary. Make sure the terms are something feasible, because the trustee is supposed to repay the terms of the note to the trust account. Where is the trust account? That depends on where you set it up. So, the good thing is, if you default, you really can't default. But even if you did default, you're repaying the trust for the terms of this promissory note. So you got to make sure it makes sense. It's got to be a valid contract. And whatever, this is where you have to do a little bit of your own research. That's why, I said an easier route would be to go to one of the legal websites and buy one of their promissory notes tailored for your state or whatever, so you know that you met all the public face of the instrument requisites, or whatever you want to call it, right? So that you can get through all of those doors, because you're going to have to get through all of those doors. And that's all I say about the public side of the instrument, right? Or the public side, but maybe we could call it that. But I am talking about the front of the instrument. So for the rest of this, I'll pretty much be talking about, if we're talking about, I'll be talking about the back of the instrument. This was something I was preparing, but this deals with the transferring of the security. This is a certifying officer on the back. Many people have heard this term before, this medallion stamp. You should look it up, research it, research what it is, research the effect that it has on unmarketable securities. And you're not going to find it by Googling those terms. I'm just telling you that when you read about it, conceptualize, comprehend what is the purpose of this thing, what is it for, and you will find that it may have a purpose in your process. I'm not saying that you have to do this, but there is a particular place, and we will get to that in this video when the time is appropriate, that suggests if you're doing the transaction one type of way, you might need to make a certain assignment on the back of the security, and you may need a certifying officer, and that is laid out in the Code of Federal Regulations. And if we don't get to it, I am definitely going to leave you some PDFs, as I said I would, that has all the laws and statutes broken down that I've used to come to the determinations that I came to of how this should be done. So even if I end this video right now, if you go pull the records that are associated with this, you will be complete, and I think you will be Gucci. You will be good to go. All right. So get you a good promissory note. Now let me mention some things real quick. One of the things that I had to learn the hard way, some of the things that other people probably have learned, especially people who have tried to get signature guarantees on their commercial instruments, such as promissory notes. They may have been told that their promissory notes are not securities, or that we don't do this for promissory notes and different things like that. Well, this is the difference in how your mind works and how my mind works, and how you need to some degree, and I'm not trying to sound conceited or arrogant in any kind of way, but you have to have a renewal of the way that you think about some things. When they told many people, I know this, that your promissory note wasn't a security, that was a roadblock for you, and you just turned away and you never went any further than that. Now what I did is, that was a key word to me, that what I knew, and this is how I deal with public officials, because we know that they're trained for the limited scope of their job. So you listen closely to what they say, because many times they're just regurgitating information and they don't know the essence of it, and you have to go back and get the essence of it, because they're just regurgitating information. So when they came back, and and I actually never was told this personally, but when everybody kept saying, oh, they won't do this because they're saying the note isn't a security. Well, I knew they can do it because I've done similar things before, but I had to go research that. The first thing I researched is a promissory note a security? Yes, no. Like, I did something like that. I Googled something like that, and then you will come across certain legal research and studies where this thing has been debated back and forth. So the solution for me was to simply look at, okay, where this thing has been debated, what is the criteria? So then you find these case laws where the court sets forth what determines whether a note is considered a security or not a security. So I said, okay, well, all of these different things that I find, let me make sure that I put all those band-aids on here. And then once I put all those band-aids on there, that was never a question of whether or not the instrument was a security when I was involved in certain research parts of this transaction, or whatever you want to call it. So I'm just kind of sharing that with you. Probably doesn't make sense what I'm saying to everybody, but that does make sense to somebody. And that information I am going to also have in the points of authority, let's call it, the research points that I've put together, my notes, that's going to accompany this audio / video. So, but the main thing is that the maturity date on your note has to extend more than 9 months. It has to be at least 9 months. And that's one of the main requisites to make sure that what you have is a security. So that's key right there. Well, another one of the other simple things is, as I said before, you have to have the UCC file basically when you walk in the door. That security, that instrument has to already be registered. You already have to have a book entry on it, because it shows that there's an entitlement or security interest already. It's no longer a question about is it considered, it's already recorded. So those kind of things right there address that matter. So like I said, we talked about the face of the instrument. I'll put some statutes in here that kind of back that up. That goes along with the face of the instrument, if you will. So we've created a valid security, right? The valid security is legal tender. In the other videos we covered why promissory notes are legal tender. So now we've established for a fact that it's a security, and we know that the security is a legal tender, and now we have to figure out how to tender the security, making sure that they accept it, right? So I guess we're killing two birds with two stones, and this might be the new thing that people have had to do, because many people, of course there's a lot of people that suggest that you could just create a promissory note and the banks have to take it, right? And then people find out the same old thing, just like with the put a red A4V on a piece of paper, is really not that quite simple. You still have to understand something. So we're trying to get just a little bit further in depth and point some things out that may make your plight a lot easier, better, fun. Okay, so we're killing two birds with two stones. We have a valid legal tender, valid instrument. We covered all of that, and now we want to make sure that they accept it. So, that's why I was hesitating, because before I go into that, there's one other thing that we didn't cover, the most important thing that we do have to cover. We did the affidavit, that we talked about the note. We go back to that part. The UCC filing. You want a UCC recorded on that instrument. It goes back into everything we said about keeping the private books. Is consistent with restrictive and special deposits. It shows that you're maintaining a security entitlement in that issue. I encourage you to read Article 9. It deals with secured transactions. And there's other places in the UCC to read too, but read the instructions for the forms. Maryland is a good place to read their instructions on their website. But go into the UCC and don't be intimidated by this, but use common sense, etc. So the way that we're going to effectuate that is by a promissory note, where the trustee borrows from the estate. That's going to be affected here on the UCC. That's why the debtor, which is going to be the trustee, so he's Doe Jonathan. Okay, and you put the address in there. Now, there's some now this is what I want to talk about here. Indexing. From my understanding, not all, but a large amount of the commercial paper, when I use the term people are banking on your estate, when they're creating money off of you, so to speak, it is indexed against your trade name that matches up with your legal address, which is on your state ID or driver's license. which when you apply for that license, you gave them the governing document, which is the certificate of live birth. You gave them that governing document, which is evidence of the estate, and you might have gave them the social security number, which is a social insurance policy. So I'm just saying all that to say there is the tie-in of how people index to your estate. They attach in, they index to the proper estate, which that estate is identified by the governing instrument, the birth certificate. So I was just basically trying to show you the indexing path of how this all gets down to your estate simply by using a name, a trade name, and a trade name and an address, or what you would just call a name and an address. This is why if somebody's giving you a ticket or something, they want to see your identification card or something so they can match your name and address. This is why a lot of people that try to stick liabilities on you, they don't want you to give them a passport because it doesn't have the proper address, so that they can index to the appropriate application so they can tie these obligations into your estate. And then they have to work harder to get that information to you when you show up for a summons or something like that. So, now on the other hand, this also reveals to me that there's multiple money creation processes, which are functions of government that take place in the backdrop, and they're charging commercial instruments all the time against your estate. So they're basically funding things based off of your credit. The same thing to some extent that we should be able to do, and I shouldn't say off of your credit, but off of your credit, off the credit of the administrative estate, right? So this is essentially what we're doing. So you have to be cautious, because there is a possibility. Actually, there's a strong possibility. I'm sure it will happen if you do the indexing the proper way, using the trade name and the proper address, the domicile address or the residential address of whatever is currently indexed. You will index this commercial process of whatever you're doing down here against the trade name, so you'll be charging the debtor, so to speak. So now imagine if you were doing this to somebody else, you would affect their credit horribly. You can drive somebody's credit score down into the 400. Trust me, I know. At this part of the game right here, I'm speaking for something that I've done before. So you want to be very careful. And this is why a lot of people's commercial liens, when they learn this process, why they didn't really take effect, because people didn't understand the indexing. So this is very important. That being said, you don't have to. You can put your name up here as an organization name. You could put the trade name here as an organization, and I don't think you're going to have the same issue, but I don't know what result will come of it. But anyways, don't get too wrapped up in that right now. This is just the initial registration of that security. So now it's a private instrument. It's not a marketable security at this point, from my understanding. But anyways, okay, so let's go through the rest of this real quick. Here's another very important part. This is something really important that you got to get. We talked about the indexing. Oh, one other thing I want to mention on the indexing. If you did go through some type of commercial lien process, or let's say an administrative process. And here's another thing. You know how they tell you that commercial lien takes 90 days, total days to cure, or something like that? Here's my understanding of what that is about. And this kind of just really kind of dawned on me today. And say, for example, in this transaction, and this is not the right financing statement for it, because this is the initial registration of the instrument. But it can be. Actually, this is the one, because before I can express to you what I'm going to say, let me go down to this part of the financing statement and say there's a space here for an assigner. This is this is for the fiduciary that you're probably going to give this promissory note to. It might be an attorney, it might be a CFO, or whatever. But this person is going to be one who ends up the person with the obligation on their back, the commercial lien, if they don't settle the transaction. So anyways, I was going to say, where this whole 60 to 90 day process of curing comes from, and what I mean is curing is before your commercial lien is valid, is the fact that when you first tender the instrument, something I've been saying in the previous videos, you have to have the UCC on it for many reasons. Well, this is again is one of those other reasons, because it's the evidence that the clock is now ticking, right? So now that you have this registered security entitlement of what it is, because the issue came out of the estate, boom, the estate has a security interest on it, but it went as a special or specific deposit for a specific purpose, right, to discharge a certain account. And what happens in the first, you asking for the statement of accounting or whatever, you got about that initial 30 days where you come up with a notice of fault opportunity to cure, and then they might have another 20 days or 15 days or whatever. And if they keep defaulting through this whole thing, you end up with a default and dishonor. You might have done a notary protest. You might have done, but you have some certificates of non-response, certificate of dishonor, consent judgment. Anyway, that whole process, you're looking at 60 to 90 days. And that's the perfection of that security interest, because it started out as just a security entitlement, which is not really a perfected security interest. But now you go through this administrative procedure and they keep defaulting. What you're going to end up with is a commercial lien. Now, once again, if this stuff is indexed properly, it will have an effect that only you can remove, and that I'm certain of. So it might be necessary and serious enough for you to hire a private investigator to see if you can get the information on that person's doing business license or whatever. Now, at the same time, if you're dealing with an attorney, you don't necessarily have to get that information. You can get the information of the organization they registered with the Secretary of State, their LLP, and then you make sure you pay for that filing information, and you make sure that you use their address of domicile and all of that, so that if it turns into a commercial lien, because they default on their duties and their obligation, if it turns into a commercial lien on their commercial vessel and all of that, then your whole administrative process, your due diligence is there, and the indexing will occur because you use the proper address so that everything can link in. Once again, my understanding with the indexing is all commercial paper is tied to some type of asset, and that's what the indexing does. It ties it into the asset, whether that be somebody's estate or whether that be a particular piece of the earth where minerals and different assets come from, and those have their own types of legal descriptions, which are like real estate legal property descriptions, where they talk about the leaps and the bounds and the easements and things, and then in some places they codify that too. So I also brought that up because since this is going to be a real estate transaction that we're trying to settle, we probably are going to click the box on here that's going to says that this financing statement is to be recorded in a real estate records. Now, you're going to do a 1 and an AD. Now, your forms are going to slightly differ, but the content really is going to be the same. It's going to be a real estate transaction, and somewhere down here they're going to ask you to describe or define the real estate, and there's where you would put the legal property description. Why? Because of indexing purposes. This is a financing statement. What is the collateral attached that's going to fund this, this balance or whatever. So that's for more for indexing purposes. Now, okay, so now one of the most important things that I'm learning that I wish to share with you is, well, one, we are supposed to be operating in trust. Many of us know that. So always, from my understanding, your UCCs are going to be a non-UCC filing. That's basically saying that the security entitlement or the security interest that you're perfecting is governed in accordance with some foreign or private law, which is my way of thinking about it. That foreign private law is either your, the internal bylaws of your trust, right? Whether that's a foreign trust or whether that's a living trust, is a living trust foreign to the jurisdiction imposed by the UCC? I think so, because it's a common law. And that's the thing that I don't really talk about that, but I still think even a living trust is still under the common law, even though it's a revocable trust. And when we think of a common law trust, we think of irrevocable trust. But a living trust, I think, is the only revocable common law trust. And all trusts are really of the common law. So that would kind of make sense. Somebody can shout at me if they think that that's not correct. All right, but getting back on the Grizzly. So these are just the basic things. Non-UCC filing. That's kind of the purpose for it. Go look up UCC 9. I think it's under 203. No. UCC 9311, I think, is where 311, somewhere under there, I think it talks about the non-UCC filing, the foreign jurisdictional type of thing. Real estate records for the indexing, and then there's always going to be on a place on here where they ask, is the collateral held in trust? That's what some UCCs say. This addendum particularly says, trustee acting with respect to property held in trust. It says, check only one box if applicable. Debtor is a trust, or debtor is a trustee acting with in respect with property held to trust. That's kind of what the trustee is in this matter. He's only listed as a debtor on here because he's acting in respect to property held as trust. What they're talking about, if you hadn't noticed, is they say debtor up here, but he's not really a debtor, he's a trustee. He took out a loan from the trust. This is the trust down here that's captured right here. Now, see, notice here, I'm going to copy this real quick, bang. Now, so this has to be the secured party down here. It's got to be a trust, right? Where does the trustee get the loan from? He gets it from the Jonathan Doe Estate Trust, right? He gets the loan from the Jonathan Doe Estate Trust. It's a private transaction. Don't worry about it. It's all private. It's all private business. So, now, this is what I want to point out to you, and I want to share this with my brothers, even the brothers that help other people doing UCCs. Especially if you're doing UCCs, if somebody did your UCC and they didn't pay attention to this, don't beat them up. Send them this video and say, hey, you might want to check this out. This is love. And if you benefit from this and you learn something from this, share something with me that I can learn something from it. But this is what I wanted to point out to you. You could put Jonathan Doe Estate Trust or whatever. You could put any type of thing here to identify, as you should, that the secured party is a trust. But you know what's really going to do that? From my understanding, the only thing that's really going to do that is by you clicking this box down here. That is what's going to shift the proper gears to let them know this relates to a trust. Whether you collect this one, that the debtor is a trust, or whether you clicked this one, that the trustee is acting with respect to property held in trust. Because either way, that lets them know with slight difference that this is a trust. So that, and even this, may have something to do with that it's a trust. So this is not, although you can put John Doe Estate Trust or whatever type of the name of the trust is, you can put that here, but this is not the emphasis of what this is for. And it is supposed to identify the trust, but I want you to understand what I have here, what this is, which I keep referring to as a trust registration statement, because my understanding of this is what changed completely from now hereforth the way that I do my UCC financing statements. One reason is because one thing that I understand that many people probably don't understand yet, hopefully you'll understand it after this video, is that when you are recording information on these financing statements, you're setting up accounting and you are setting up accounts and you're registering securities, and this is a private book entry account, right? So that being said, everything has a significance. The secured party, essentially, if you understood that you were setting up account, you would know that the secured party is essentially the account owner. And it actually is the account owner in regard to this security entitlement or whatever's in the account. and this is a security account. So essentially this security account can be moved in a different type of security account. This type of particular security account doesn't come with an ATM card or a checkbook, so it's not really of use to many people at this stage, so they don't really pay attention to it, nor do they look at it as an account, nor do they see the potential of what could be done with it, because it doesn't act like the account that they're familiar with. But now on the other hand, think about your Bank of America account and whatever other bank accounts that you have. You can transfer assets between your accounts as long as you're the account number, I mean not your account number, but you're the account owner between all the different banks. If you're not the account owner, then other pieces of authentication and things have to take place before the transfer of that money, those funds, or that security, or whatever. So think about that in terms of the different things that you write on the UCC. Now, so the secured party is a trust. This is a trust registration statement. Let me show you. I came across this again. I spoke about this. Many people that's doing the secured party recording. By the way, you can do that donating $150 to thctrust.org. If you want more information about that, send me an email, coaching@thctrust.org, and I'll tell you, or I'll send you an email about what the outline for the secured party recording stuff is and what all that's about. So let's see. Okay. But in my research for that, that's where I learned about the trust registration statement. Let me share that with you. Okay. So I'm going to bring up the master file. The master file blueprint. Some people are familiar with this. Some of you aren't. So in the master file blueprint, there's a document in there. And if you don't have access to this, you can Google this. It says trust registration statement. And what you can Google is Google a document called Questions and Answers About Trust, publication 0049. This is a document from the Treasury. And what I want you to pay attention to in here, scroll all the way down to the bottom, and they have this part here where they have sample registrations. These are called trust registrations. I call them trust registration statements. And the Treasury is not the only one that uses these. They use these in commerce. I've learned this because when I was doing some research, I seen a secured transaction that an attorney had set up, and he used a trust registration statement. And I was like, oh, that's interesting. And this is how I learn a lot of things, because my mind is always making correlations and putting one and two together. Then I opened up an account with a brokerage using a living trust indenture, and I noticed that they created a trust registration statement based off of the information in my trust. And then I said, oh, this trust registration statement is important, because even the Treasury Direct, when you open up a Treasury Direct account, especially if you're opening up a trust, or an estate, they tell you there's a spot in there where they want you to give them the trust registration statement, and they express how important it is, although they let you put whatever you want to put in there, right? And I don't think many people really think about how significant it is. I know that I didn't. And the first time that I tried to do this stuff where you tap into the Treasury and redeem and get all your money and everything in the world, believe it or not, just to make a long story short, in my search and my trip down the yellow brick road, that trust registration statement became an issue. And that's why I kind of understand it right now, because somewhere down the line of me trying to do things, I realized that my trust was set up wrong, and that is a factor. So this is a jewel I'm about to drop down on you. And by the way, if you're digging this, visit www.thctrust.org, join the premium subscription group, and donate $24 a month. Anyways, this is a trust registration statement. I want you to pay attention to what the Treasury wants. And I don't even really know what this is connected to. I don't even know where I found this. This might be directly for Treasury Direct. Who knows? But I'm going to explain some more about it afterwards. So this is a key, if you will. Here's an example. This is a tax ID number. 10th National Bank trustee under agreement with Paul E. White, dated 2105. So what is the syntax we see here? Tax ID number, the name of the trustee, under agreement with, the grantor or whoever is in that capacity. then the date the trust was funded. That's the syntax they want. Here's the abbreviation version of it. They give you all different types. This was a corporation being the trustee. Here's another different type. Carl A. Black and Henry B. Green, co-trustees, under agreement with Paul E. White, dated, and there's the date the trust was funded. Notice again, first they have the tax ID number. I want you to pay attention to the syntax, because this registration statement, in my mind, is like the social security number for a trust. And this is why the Treasury, even when you're setting up your stuff, they harp on the significance and the importance of that registration statement. And then they let you run off and mess it up. So you got to kind of overdo some research to figure out what that is. And if you still don't quite understand what it is, maybe this will help you. I believe it expresses to the world of commerce with specificity, or whatever that word is, the exact trust that you're administrating. So it's non-ambiguous. It can't be falsified or altered, because this establishes a record with precision. Now, this had became an issue because a lot of us, and what I was trying to do, is create a foreign trust of the trade name and then attach that trust to the securities attached to the social and the birth certificate. And I was trying to redeem all those securities, and a lot of us have done this with different foreign situs trusts and things like that. And I'm not saying that I'm the guru and that this is the way, but this is what I was looking at before I understood and comprehended the living trust. But more importantly, what I want to share with you, what I understand and the way that I understand things, is that everyone who is born in the United States, in this whole class system thing and all of this stuff with the birth certificate and everything, there was an administrative estate set up at birth in a trade name for every living man and woman that was born here. There was and is a very specific one that can be identified with specificity, or however you say that. I can never get that word right. And what I was trying to do before, I created a trust and tried to, by association of the name and, using a foreign tax ID number, which never quite captured the exact administrative estate that they're considered abandoned. The same one that they're considering abandoning, that they're doing creating the securities under the SESTA-KV Act and all of that. So if you look, right, let's go back and look at this financing statement here, and you could look at, there's other places where this will come into play too, just like when you open up certain accounts and they put the registration on there. Now it's an identifying number of the owner of that account. The same thing right here. It's the identifying number for the owner of the account of whatever you got down here in the collateral, the account of whatever this is. But this is for other people in commerce, in the banking game, and the game where they're doing indexing and creating currencies against trade names and assets. This is how they can identify with exactness, right? So, following this syntax, I figured it only makes sense for me to use this syntax, right? Now, think about the living trust. This is what I want you to think about. Let me make sure I hit everything, because so what you see right here, this is how your living so this is how you identify a trust, whether it's a living trust or whether it's a irrevocable trust, or whether it's a revocable trust or an irrevocable trust. This, you have Jonathan Doe, trustee under agreement with the United States of America, doing business as Jonathan Doe. That's how I do my living trust, right? Why do I say under agreement with the United States of America? Because the governing instrument is a certificate of live birth, and it's an obligation of the United States Treasury. They created it. It's the agency, instrumentality of the United States, till you demonstrate competency, show up, and trust. So it's Jonathan Doe, the trustee, under agreement with the United States of America, doing business as Jonathan Doe. What date do you think we should use? What date was the trust funded? We're going to leave that at that. I'm not going to go any further into that. I know I just left y'all suspended in real air. Some people I didn't leave suspended. Some people was like, Oh shoot, Tex, my man. Some people was about to pee on themselves. We're gonna take a little break and let you go pee, because I just dropped a jewel on you. But nah, no, for real, man. People, I hope you understand that the date. So this is what I understand, man. No, you know what? We're just gonna keep rolling with this for now. I believe the date that the trust was funded is the date on your certificate of live birth, the date it was filed. That's the evidence of the trust. Because that trust doesn't change. Although this is a different instrument, we're not talking about the birth certificate. This is the registration for that specific trust. Alright, we're going to kind of leave that at that, because I kind of like went all in, and I know, I don't want to make this any further and longer. So, anyway, what we will say is, so there you have some insight on the UCC. You did an initial registration of the promissory note. Now it has a commercial existence. Now that we did all that, we have to find someone to take it, and we have to figure out how we're going to get them to take it. Which ways can we go? We can go administrative procedure, and we're going to always try to go that way, but there's some other ways too that we're going to discuss and that we're going to talk about. I hope I bored everyone to death that is just looking for a quick silver bullet remedy. Alright, we'll pick it up and we'll continue on in the next video.